On July 28, 2016, a 14-year-old girl in Warren, Ohio, shot and killed her father while he slept. She was arrested and charged with aggravated murder. When investigators asked why, she said she was afraid he would kill her mother first. The police had been to their home before. Reports existed. A protective order had been sought and later withdrawn. Calls were made, files were opened, and nothing changed. Bresha Meadows was not the first person to report that her father was dangerous. She was the last. At 14, the system that should have protected her family had run out of answers. The Meadows family lived in Warren, a mid-sized city in Trumbull County northeast of Youngstown. Jonathan Meadows' violence against his wife Brandi and their children was neither secret nor brief. Neighbors and extended family knew of injuries, bruises that faded into stories, fractures that became explanations. The physical marks mirrored a daily reality in which the threat of violence was constant. The children learned to move through the house with the practiced silence of those who track mood and footsteps, who measure the risk in a raised voice or a slammed door. Bresha, the youngest, carried those rhythms into her adolescence. By the summer she was 14. Her life had been shaped by a persistent pattern: plead for intervention, receive documentation, return to danger. Records show contact between the Warren Police Department and the Meadows household stretching at least to 2011. Brandi filed police reports in 2014. She sought a protective order, a legal mechanism intended to interrupt abuse by prohibiting contact. She later withdrew that petition, a choice that must be read against the power dynamics of domestic abuse, fear of escalation, economic dependence, and the realistic assessment that an order on a page does not always translate to safety on the street. Officers responded repeatedly to the address. Each response followed recognizable steps: dispatch, arrival, assessment, report. Rarely did those steps culminate in sustained removal, alternative housing, or a comprehensive safety plan for the family. Documentation accumulated, protection did not. In the months before the shooting, Bresha articulated the fear that would drive her action. She told a relative that she believed her father would kill her mother. That statement, delivered by a child convinced of imminent danger, reached adults who had standing to notify authorities. The communication entered the record in some form. Still, no intervention changed the practical circumstances inside the home. Jonathan Meadows remained. Brandi and the children remained. The cyclical contact between agency and household produced paperwork without a break in the sequence of violence. The danger Bresha described persisted, and the avenues meant to prevent escalation failed to do so. On the night of July 28, 2016, Bresha shot Jonathan while he slept. She did not deny the act. In interviews with investigators, she explained that she believed killing him was the only way to stop him from killing her mother. There was no theatrical bravado in her explanation. There was the weary reasoning of a child who had watched the slow erosion of protection and decided the calculus no longer favored waiting. Her family corroborated the history of abuse. The existing police files corroborated it as well. The factual record before the shooting contained long official traces of the threat that preceded the moment she acted. Authorities charged Bresha as a juvenile with aggravated murder, the gravest charge available to Ohio prosecutors. She was held in a juvenile detention facility while the case unfolded. The prosecution drew national scrutiny. Domestic violence advocates, legal scholars, and civil rights organizations framed the indictment not as an isolated legal matter, but as a symptom. A juvenile justice system asked to adjudicate the consequences of failures elsewhere. They argued that charging a 14-year-old who had endured and reported sustained familial violence amounted to prosecuting a child for the absence of protection she had sought. The debate that followed centered on culpability, proportionality, and the responsibilities of institutions that had prior knowledge of the danger. After months of legal maneuvering and sustained public advocacy, Bresha entered a no-contest plea to involuntary manslaughter as a juvenile. Her sentence included a period in a minimum security juvenile facility and mandated mental health treatment. She was released in 2017 at 15. The legal resolution represented the most favorable outcome available under the framework that had charged her. It did not and could not rewrite the years that preceded the shooting, the calls to police, the withdrawn protective order, the conversations in which a child warned that her father would kill her mother, and the absence of any systemic intervention sufficient to alter the family's trajectory. The pattern seen in the Meadows case is not unique. It reflects a broader, documented failure in the way institutions respond to intimate partner violence, particularly in households where children are present. Research and practice in domestic violence intervention demonstrate that reliance on episodic law enforcement response, absent sustained safety planning, and survivor-centered advocacy frequently fails to halt cycles of abuse before they escalate. Protective orders can be effective tools when accompanied by enforcement and when survivors have meaningful access to alternatives. When withdrawn under pressure, they produce documentation but not safety. The criminal justice system's emphasis on arrest and prosecution, without parallel investment in prevention and support, can leave those most at risk, including children, exposed to continued harm. The public conversation around Bresha's case focused attention on a gap in legal frameworks. The assessment of juveniles who use violence in the context of documented abuse. Advocates argued that traditional self-defense doctrines and prosecutorial approaches often do not account for the lived reality of children trapped in violent homes, minors who cannot simply leave, who lack independent resources, who narrate imminent danger, but whose accounts confront institutional skepticism. The case became an example invoked in calls for reform, for courts to weigh histories of abuse more fully when evaluating charges against juveniles, for child welfare and criminal justice systems to coordinate more effectively, and for protective measures to be practical rather than purely procedural. Bresha's subsequent public advocacy for survivors and for systemic reform converted personal tragedy into a platform for change. The Meadow files, the police reports, the withdrawn petition, the statements from relatives, bear witness to what internal failures look like when written down. They are not blank. They are crowded with entries that, taken together, constitute a continuous record of risk. The formal record is a ledger of warnings that did not translate into altered living conditions or decisive protective action. When the documented danger culminated in a child deciding to act on behalf of her mother, the record served as a retrospective inventory of missed opportunities. That reality forces a difficult question. At what point does institutional inaction become a contributing cause of the violence it later adjudicates? On July 28, 2016, when the 14-year-old decided the system had run out of time, she effectively answered that question for herself. She spent a year in juvenile detention. She was released and has since engaged in public advocacy. Her father's history of abuse was recorded in the police reports the entire time. The outcome, criminal charges, confinement, plea bargaining, did not erase the sequence of official contact that failed to secure safety. The Meadows case remains a cautionary illustration of the limits of documentation without protection. Subscribe to Case Files TV, because when a child picks up a weapon to protect her mother, every institution that came before her has already failed.